And now we are going to move across to Lavanya. Lavanya, are you there? I think you are there. Is Lavanya there? She is. Brilliant. So, Lavanya Rajamani, Professor of International Environmental Law at the Faculty of Law, University of Oxford, and also the Yamani Fellow in Public International Law at St. Peter's College, Oxford. And she is going to give us a keynote address on climate litigation, the second best option for governing climate change. And I like that. So go ahead, Lavanya, with your speech.
Thank you, James, for that introduction, and to Bickel and Hossel for inviting me to offer a few remarks on this occasion. The title of my talk, which was suggested to me by the organizers, I should say, Climate Litigation, the second best option for governing climate change, does obviously beg the question of what the first best option is. And the first best option is one that has been discussed by Laurence and others, and with conflicting views in the previous panel. The answer, I think, to what the first best option is obvious. The first best option for dealing with the global collective action problems, such as climate change, at least most lawyers would agree, is a comprehensive, multilaterally negotiated, binding agreement with shared goals, concrete, precise, and tailored obligations on mitigation, adaptation, and support, and mechanisms to ensure transparency, accountability, and compliance. This, however, at least envisioned in this sort of comprehensive way, proved impossible to secure. And some, of course, social and political scientists would actually argue that that's not the way to generate the fundamental systems transitions we need to address climate change. However, what we do have is the Paris Agreement, and it is, whatever one may say about it, it is a tremendous diplomatic achievement, but it does give rise to very conflicting views, entirely justified conflicting views. What is clear, though, is that as a result of the political dysfunction at the heart of the international climate change regime and the politics at the heart of the regime, it has at least three consciously negotiated governance gaps. And these are gaps that national, regional, and increasingly international climate litigation is seeking to address. So what are these three gaps, governance gaps in the international climate change regime? The first is the ambition gap, and that's the most obvious and central of the gaps that we have. The centerpiece of the Paris Agreement is, as we all know, a binding procedural obligation placed on states to submit nationally determined contributions. But there are a couple of things to note about these procedural obligations to submit nationally determined contributions. These are, first of all, as the term suggests, nationally determined, not multilaterally negotiated. So states are given a great deal of autonomy in setting these targets for themselves. There is no mechanism to review the adequacy of national contributions in relation either to ambition or to fairness. And there is, of course, no obligation of result attached to the content of the nationally determined contributions that states undertake. What this has resulted in is a situation that we're currently in, that contributions do not add up to what is necessary to achieve the purpose of the Paris Agreement, which is to hold temperature increase to well below 2 degrees centigrade and striving towards 1.5 degrees centigrade. The first round of NDCs put us on track rather to over 3 degrees temperature increase. And the current NDCs, including the updated ones, which are 47 countries at last count, plus the EU, are estimated to put us on track to 2.4 degrees temperature increase. If all the net zero targets are met, or the announcements that have been made, if all of them are met, then we might reach 2 degrees temperature increase. But of course, there are very serious questions of credibility and accountability in relation to these net zero targets. The second major gap, the governance gap in the climate change regime, is an accountability gap. There is no mechanism to generate individual accountability for compliance with the targets taken by states. So although states are required to provide information with their nationally determined contributions, they can actually choose the information requirements that apply to their type of targets. There is an enhanced transparency framework, but this framework excludes a robust review function. And indeed, some scholars have actually argued that transparency takes the place of accountability in the UN climate change regime. There is a compliance committee, but it is facilitative and it's limited to ensuring compliance with a very small subset of binding procedural obligations. So the accountability for targets taken and their achievement is actually being demanded by non-state actors, actors outside the climate change regime. The third gap is a fairness and equity gap. And this issue, the issue of fairness and equity, which has been a central issue in the climate negotiations right from the start, the issue of how to fairly share the burden of addressing climate change, is an issue that has been deeply contentious over the years, and is an issue that the Paris Agreement deftly sidestepped in many ways with a move towards self-differentiation and national determination. But it is a question that is now cropping up in climate litigation, challenging the adequacy of national action. There are very few avenues left for dealing with fairness and equity concerns in the climate change negotiations. The global stocktake is perhaps one of the few avenues left for that, and I'll come back to that at the end. So there are these three very fundamental gaps, and fundamental, deliberately created gaps because of the political dysfunction, gaps in the climate change regime. Now, climate litigation in national, regional, and international courts even has picked up pace in the last 5 years to address these gaps, increasingly on human rights grounds, but to address these three gaps of ambition, accountability, and fairness in relation to actions by states, but in some cases also actions by non-state actors, like the judgment against Shell in the Dutch courts. Now, to give you some examples of cases that are trying to do this, to address the ambition gap, of course, the now famous Urgenda case was the first and most successful in addressing the adequacy ambition gap in relation to the Netherlands, but is by no means the last of such cases. The recent Neubauer case in the German Federal Constitutional Court also spoke to the adequacy and ambition gap in relation to the Paris Agreement, in relation to Germany's commitments in relation to the Paris Agreement. The accountability gap is being addressed in decisions that are demanding greater specificity in national climate action plans and an alignment of short-term plans and actions with long-term targets. The Friends of the Irish Environment case and the Neubauer case are examples of this. Now, it's particularly important to align short-term actions with long-term targets in a world in which net zero targets have become the center of the conversation. Net zero mid-century targets have become the central framing, framing for the conversation around climate actions. Alignment of short-term actions with long-term targets is critical, and courts are beginning to take this up. The equity fairness gap is also being raised in national and regional climate litigation. Now, in these courts, when claimants are actually arguing that climate ambition, the national climate ambition is inadequate and needs to increase, the courts are obviously going to ask against what concrete benchmarks is the national effort to be judged in the context of a collective action problem. What is each country's fair share? This is one of the central issues in the Portuguese children's case that is pending before the European Court of Human Rights, was also addressed in the Neubauer case. So climate litigation, national, regional courts predominantly, but increasingly perhaps in international courts as well, is seeking to address these fundamental governance gaps in the Paris Agreement architecture, gaps on ambition, accountability, and fairness. But litigation, to go back to the title, is clearly a second best option because it does have serious limitations. Successful cases are still few and far between. Most of these cases actually fail on procedural grounds such as standing. Even where procedural hurdles are clear, depending on the claim, the elements of the claim may not be made out. Causality, where that is relevant to the claim, is difficult to prove, although there are, of course, advances in attribution science that has already been alluded to. Sufficient scientific evidence may not exist or may not be state of the art. So much of the science that is relied on in these cases is IPCC science because it is incontrovertible to some extent, 700 authors across developed world, but IPCC science, because the time scales, it does take a little while for those reports to be produced. So it may not be the most state-of-the-art, latest scientific evidence that's being relied on. The legal culture in some countries may not be one that fosters what my colleague here at Oxford, Liz Fisher, characterizes as legal imagination. And the judicial culture as well may not be one that is supportive of activism. In South Asia, the judiciary produces what a former colleague of mine, Pratap Bhanumetha, a leading public intellectual in India, calls the jurisprudence of exasperation. It leads, as we've seen in cases like the Asghar Leghari case in Pakistan, but to very compelling and proactive judgments. but most other judiciaries are reluctant to step into the domain of the legislature, as we have seen in the Juliana case in the US and in other cases. So even if successful, though, as a response to the global collective action problem of climate change, litigation is only ever likely to be a piecemeal solution. To take a small example, for instance, on the issue of fair shares, different courts are actually arriving at different metrics for fair share. The Neubauer case may be equal per capita, and another case, a different metric for what a fair share might be. Not all countries are actually even engaging in this question of fair shares. So how is this all going to add up? So it has to add up, and that's the fundamental reality of our engagement with climate change issues. So what this highlights, to conclude, is that we need to engage on multiple fronts. On the first best option, we need to strengthen the international regime in at least two ways: find rules and craft rules going forward that discipline national autonomy and discretion, and design the mechanics of the stock take, which is to happen in 2023, to be a significant moment of reckoning for the international community, such that it actually functions substantively to leverage ambition, both on mitigation and support, and to ensure fairness. And on the second best option, we need to continue to litigate, as Laurence also said, in creative ways, multiple cases across jurisdiction with ever more compelling state-of-the-art evidence, imaginative argumentation. But we need to do this in a way that's coordinated across jurisdictions. And I think non-state actors are beginning to do this with reference to case law across jurisdictions, so that there's cross-fertilization across different judgments and there's a shared direction of travel. And finally, there's also the possibility to canvass an ICJ advisory opinion that could potentially clarify and refine aspects of the Paris Agreement so as to discipline national discretion, and also speak to the customary international law obligations relating to due diligence that states have in relation to climate change. So to conclude, we need to work not just on the first and second, but on every conceivable option to address climate change. Thank you.
Brilliant. Thank you so much, Lavanya. I much enjoyed that presentation. Forgive me if I move on to our panel, because we've got amazing people lined up and not much time. But I would like just to carry away from your presentation something that I would hope featured in our further conversations, which is the essential task of connecting advocacy that works inside a courtroom with advocacy that might work in these other domains, in the political domain, in the civil society organization, in the corporate domain. We need to be persuasive in all of those multiple levels that you referred to, if we're going to provide the scale and effectiveness of response that we need to the emergency that you've highlighted. Thank you very, very much.